Hello, this is Joseph Zoll. About making a will. Very important is without a will, the probate court will make the decisions without you. And if you have underage children, the family court will decide custody without you. I'm giving practical advice here, not legal advice, but it is important, so please stay with me. I'm assuming a married couple with underage children, and considering the possibility we don't want to think about that both die simultaneously, as in a car accident, for example. First, have your mind made up about what the will is going to provide before you meet with an attorney. Once you are in front of your attorney, the meter is running. Costs are piling up for you, and that is not where you want to try to make a decision of importance. The attorney's job is to take what you already decided and put it into legal language, and caution you about the law, depending upon what you might be trying to provide for in the will. Second, lawyers are a profession, but they are also in a for-profit business. Some lawyers go overboard, sending you a questionnaire about everything. How much you have in your 401k, how many cars you have, do you have a vacation home? These questions can be good triggers for you so you don't forget anything. But some lawyers try to use any information about significant assets as ammunition to convince you to set up trust funds and the like when you don't really need them. Some people need trust, many people do not. Use a lawyer who will focus on your will exclusively, and you can explore the other points later on. Third, you can make bequests of specific items, such as your house, your family photographs. As to stocks, bonds, bank deposits, financial matters, reconsider making a specific bequest in dollars, such as $10,000 goes to this person. Your financial situation will change over time. Consider making a bequest in a percentage, such as 1% to this person and 2% to that person of your liquid assets. Fourth, the most important people are those who will have positions of importance. These are primarily your executor and who will take your children in. First, have backup. Suppose you have designated an executor who dies before you, or is in the middle of a divorce or bankruptcy when the time comes and just can't do it. I suggest a second and even a third choice. Second, whomever becomes your executor should receive a bequest. Even with a small estate, there is a lot of work that will be involved and some expenses will come up. Plus, the individual's time is worth something. Third, a bequest should be made for those who will take in your children. You can set up a bequest for your children, for their college education and such, which is where a trust fund might be the right answer. Not necessarily. But the family is going to be providing food, clothing, and shelter for additional children who will now be part of the household. Love is great, but in our practical world, money is important. What bequest will you provide to whomever takes the children in? And to have backup, a second and a third choice. And on these bequests, the executor and the children's new guardians should know what the entire deal is in advance. No one else needs to know, as you may have a falling out with someone or for some other reason make a change in your will. Fifth and last, review your will at least once a year. Pick New Year's Day or your birthday, a date that will be your annual review date. You may decide to change nothing, or you may decide on major changes. Before we go, here are some additional videos on this channel right now that can be of interest to you. Do like, subscribe, and hit the notifications bell. Thank you for joining me today.